Hello, welcome to you all to the second offline talk of NUJS Chapter. Today we are very grateful to have Mr. Sarthak Roy with us, and he is giving our lecture on demystifying the UN human rights system, witnessing accountability in action. We are very grateful sir, to have you today with us. And to give a very brief overview about Mr. Sarthak Roy. So currently Mr. Sarthak Roy is working as an assistant research officer at the Commonwealth. And Mr. Sarthak Roy has completed his BA LL.B from Christ University, Bangalore, and postgraduate diploma in international law from Indian Society of International Law and an LL.M in international human rights and humanitarian law from Geneva Graduate Institute. He also has been previously part of International Human Rights Law Fellow in the Office of Foreign UNSR on freedom of religion and belief, human rights specialist Richmond Legal Clinic Project under Amnesty International Working Group on Human Rights in India and UNWGHR, among others. With this, I would like to hand over the floor to Mr. Atul Alexander, sir, for the elaborate on the topic. Thank you.
Firstly, I would like to thank all of you for taking time out and participating in today's discussion. I understand it's a Sunday, so thank you for that. And to give a brief overview of the topic, I'll not take much time. So you have been exposed to human rights, and you have a fair assessment or idea as to how human rights functions. It is important to note that in every sphere of international law, human rights has its influence, be it refugee law, be it international criminal law. Human rights has its own tentacles, right? Having said that, the enforcement, as I used to discuss in class, is very weak. That is at least from an academic perspective, right? But having said this, one needs to explore the practical contours of human rights law to understand how it operates in the ground. So, in order to highlight these aspects, we have with us uh, Sarthak Roy, as Tushar has introduced. Uh, he's part of an NGO. He's part of an international non-governmental organization, which is, if I'm right, is based in UK. Based in UK. And in order to throw light into the working of human rights law in practice, uh, Sarthak Roy would be addressing us on a very important topic, that is demystifying the United Nations human rights system. So, with this brief introduction, and for starters, as you also know, that the enforcement of human rights is also lacking because the entire human rights system is highly fragmented. You have states, you have NGOs, you have bodies like United Nations General Assembly, ECOSOC, all actively involving in the process of churning of human rights. So this has also meant that how human rights are enforced, how human rights are conceived is something that is rather marred or remains unclear. So with this brief background or brief introduction, I would hand it over to Sarthak Roy. Over to you, sir.
Good afternoon, everyone. Thank you very much, Atul, Tushar, and the Center for International Law for inviting me. I'm a Bengali boy from Calcutta. I'm Sarthak Roy. So it gives me all the more pleasure coming back to my city after a long time to give, have a discussion on international law with all of you wonderful bright minds over here. NUJS holds a lot of memories for me because this is where, with all the Model United Nations, the Moot Court, and Invictas, and everything, back in my law school days, that I had gotten so much of experiences that I was just wandering around with Atul all the corridors, and it just brings back those fantastic memories. And I'm now really humbled to be given this opportunity. So, on that note, what my discussion on this Sunday afternoon would not be is it's not going to be on theory. It is not going to be on a very nuanced jurisprudence, but it's just going to be my practical experiences, having worked with an NGO, international NGO, having worked with the UN Special Rapporteur, with a multinational company which engaged with the UN, and now finally as an international civil servant with the Commonwealth Secretariat, my experiences so far in terms of unraveling the whole human rights mechanisms, which is quite mysterious, at least it was to me when I had started off on this journey. So on that note, so I'll take the next 45 minutes to make this presentation, but in between, if you have any questions or queries, please feel free to just bring it up. It's much more of an interactive session that I want to have rather than a monologue that I want to give. So wherever you feel like, and ultimately I want to show you guys that there is World Trade Organization, there is investment law, there is corporate law. You can also build a career as an international civil servant or as an international human rights lawyer as well, and be placed globally across various difficult situations and in humanitarian conditions. So, demystifying the UN human rights system, this idea came from the very epochal words of Justice Concado Trinidad. He was a very famous international court of justice. He was a judge at the ICJ, one of the foremost lawyers who had deliberated on the humanization process of international lawmaking. And so, on that note, when I start off, I want you all to just have a look at the very famous quote, and you will see that this is going to be reflective of how the UN human rights mechanisms also came into the picture. Above the will stands conscience, which is, after all, what moves the law ahead as its ultimate material source, removing manifest injustice. There are a lot of talks that we always get to hear that international law is only dependent on the will of the states. But through this process, the development of international human rights law mechanisms will showcase that it's not the will, but the conscience of humankind across various sites of sorrows and atrocities that international human rights regimes came through. This was a very famous landmark quote from Justice Trinidad's dissenting opinion in a case which considered reparations for Nazi era crimes. So my presentation primarily would be divided into 4 parts. The second part is going to be the most important one, which is going to be the crux of this whole discussion. But first, I'll just give you a snapshot as to how the modern UN Human Rights Council and the system came into the picture in 2006 and what it was before that. And once we delve into the system, we understand what are the mechanisms for understanding human rights accountability processes. So I'll touch upon a bit on treaty bodies, the work of treaty bodies, even special procedures, the Universal Periodic Review, and commissions of inquiry. And ultimately, I'll also talk about how India's engagement has been so far with the UN Human Rights Council, and as to how India have thrown a good or a bad account of themselves before the UN human rights systems. And finally, I give you a resounding answer as to why you guys can also aspire to be future international human rights activists, lawyers, and exponents. So prior to the 2006 UN Human Rights Council, what we had right after the United Nations was born was the Commission of Human Rights, which was present between 1946 and 2006. And for the first, and it was created by the ECOSOC. Now the modern human rights system, Human Rights Council has been created by the General Assembly. But that time it was created by the ECOSOC. Initially it had 18 members and then ended up becoming, for 53 member body. Current UN human rights system has a 47 member body. So for the first 20 years for this Commission on Human Rights, the work was mostly on standard setting. And as you have already probably gone through, and Professor Atul has probably discussed with you all in his human rights classes, the Commission on Human Rights came up with all the drafts on the ICCPR, the ICSCR, and most importantly, the crux of the UDHR, which had all come into the picture. So the ICCPR and ICSCR had come up in 1966, but it took almost 10 years for it to be ratified and for it to come into action. And in those 10 years, I'll touch upon later what happened. It so happened that those treaties got fragmented, specific segments got fragmented, and each of them evolved into what we call the 10 primary human rights treaties that we have right now, which I'll showcase later. But in between this whole standard setting process, as a precursor towards the modern human rights mechanism, there were very dangerous instances and there were a lot of bloodshed that were happening in Latin America, which had pushed a lot of this discussion on international human rights mechanisms to come into the picture. For example, the very infamous coup in Chile, which was led by General Augusto Pinochet, who had overthrown the Salvador Allende government, a very famous president from Latin America who had contributed towards a lot of decolonization process, towards the whole UN General Assembly resolution on permanent sovereignty of natural resources as well. So he was overthrown. He was very much supported. He was a communist leader, but a leader who was known worldwide. And just for all those who are enthusiastic about decolonization processes, you must read his or listen to his speech at the 1972 General Assembly which he had given. So just 2 years after that, he was overthrown by Augusto Pinochet. And since this Pinochet government did not have any international friends as such, for the first time, UN mandated commission of inquiry was set up to look into the crimes being committed by Augusto Pinochet. So much so, the evidence that were gathered led to prosecutions within the domestic framework of United Kingdom, but also there was an ICJ case, very famous ICJ case, which had come through. So that was the first instance when something resembling a modern commission of inquiry had come up. Next, you will see there were these enforced disappearances in Argentina. And now, for all those who are enthusiastic about law and films, modern day films, you must watch this film called Argentina 1985, which is present, you can find it on Netflix itself. So there was this widespread enforced disappearances being undertaken by General Rafael Vidal, who had come through and had overthrown the democratic government of Argentina. And there was instances of enforced disappearances which have come through. For the first time, the world was hearing about people being disappeared and no traces of them. So what happened at that time was that led to a huge international outcry. And for the first time, something like a treaty on enforced disappearance had come through. Because the world powers, when they went beyond their will and their conscience had come through, they decided a treaty will be helpful to prevent such things from happening, not just in Latin America or Argentina, but globally, whereby the treaty would mandate states to allow treaty body members and investigators to investigate instances of enforced disappearances within the domestic framework. So that was also a precursor to the modern treaty body system that I'll discuss with you all in a few minutes' time. And finally, one of the leading key international players for the modern human rights system was Mr. Kofi Annan himself, the former UN Secretary General. In his landmark in Larger Freedom Report of 2005, he had showcased as to how human rights, just like peace, security, and economic development, is one of the pillars of the United Nations which it should aspire for going forward beyond the 21st century. And then finally, when it was realized that there is a need for an evolution on the human rights mechanisms, the UNGA passed a resolution in March 2006, and the UN Human Rights Council was created. And next, we will delve into the whole mechanisms of the UN Human Rights Council. So, as most of you must already know, and as I just mentioned, the UN Human Rights Council is made up of 47 members. India is also currently a member, serving its sixth term. I'll touch upon India's facts later. So it has 47 members, which is distributed according to a UN certified equitable criteria. You will find out. And the work of the Human Rights Council is all encompassing with on human rights, but also in terms of immediately addressing, urgently addressing human rights systems. So, what was the main difference that really came through? So, unlike in the past, when the Commission on Human Rights was there, the UN was almost like the three monkeys. I hear no evil, I see no evil, and I speak no evil. In the sense that the UN at back then, during the times of Commission on Human Rights, was very reticent in terms of trying to address country-specific situations because they were scared that they were being barred by Article 2+7 of the UN Charter, which for them prohibited in that any kind of intervention, political intervention on the country's sovereignty would really backfire. But with the Human Rights Council system and with the treaties coming into the picture, states slowly gave up some of their core sovereignty issues for the larger good of mankind and for the growth of UN human rights that had come through. And so the UN Human Rights Council, through its mechanisms, which I will touch upon, has also developed a lot of interrelated areas of law and brought it with human rights law. For example, the last few years, there is this whole intermingling of climate change, environment, and human rights that have come through, which many of you mooters and debaters on these issues will also notice as to how human rights is present. And then there is also a discussion on business and human rights, something which I was lucky enough to work upon when I was with a multinational company in Switzerland, that we had to engage with a working group on business and human rights for setting standards for businesses to follow. So, for example, in the corporate framework, you can talk to alumni members and everyone abroad, or even in India, there's this whole spurt of sustainability that is coming through in the corporate networks. ESG, environment, social, and governance. How did that come through? The social wing of that came through primarily from the UN guiding principles on business and human rights, which is also something very innovative on this nuanced aspects that's coming through. Now, for example, right now there's a lot of negotiations that's happening on right to steal, the right of peasants, to the smallest possible limit where human rights can touch human lives is where the Human Rights Council comes into the picture. So this is the larger gamut of the UN human rights system, as you can see. So basically, the mechanisms that I'll be talking about is twofold. First is the treaty-based mechanisms, which are called treaty bodies, and the treaty bodies are also called treaty body committees. So they are the 10 core treaties which I'll showcase to you all in the next slide. And those are the treaty-based mechanisms. And then there are the charter-based mechanisms, which you can see, which emanate from the Human Rights Council. For example, the Universal Periodic Review, where country situations are reviewed every 4 years or even 5 years. There's a role of special procedures or independent experts who shed light upon different human rights situations or intervene directly if there are any problems within the domestic framework of any particular country. And something which is not present here, I missed out, is the role of modern commissions of inquiry which have come up. And I showcase as to in these mechanisms how many Indians have been there at the highest platforms as well. So yes, so these are the 10 main core treaties. So I know many of you might not know the full forms, so I'll just let you guys know. First one, ICERD, or is the Convention Against Racial Discrimination. And it has a committee called the CERD Committee. The second one is the ICCPR, which we all know about, and its committee is very famous for many of its decisions and jurisprudence that it has come up with. Then the ICSER, which is the Economic, Social, and Cultural Rights Committee. And here is a little anecdote. Unlike the other 9 committees, the ICSER reports to the ECOSOC, whereas the other committees reports to the UN General Assembly. Because the Human Rights Council, as you can see, as you saw in the previous slide, is a subsidiary body to the UN General Assembly, the rest of the other bodies report to the UN General Assembly, whereas the ICSER reports to the ECOSOC. Then we have the CEDAW. We know very well in the domestic framework, the Vishaka guidelines, and so many jurisprudence that the Supreme Court has come up with. It was pursuant to India ratifying the CEDAW when there's a whole movement for preventing discrimination against women. So this and the CEDAW committee has also come up with landmark jurisprudence and even reports on behalf of many states. Then we have the very famous CAT. CAT is the UN Convention Against Torture Committee. This is after the third committee. CAT committee was the second treaty body which had come into the picture. So unfortunately, despite India having signed and ratified all the other all the other 8 treaty bodies and the treaties, India is yet to ratify the UN CAT. And there has been a lot of push for it. But yet we see custodial violence. We have seen DK Basu guidelines coming through. We have seen so many jurisprudence of the courts coming through. Yet India has not ratified the CAT. And what is much more dangerous is that there's a trend or there's this trend of cultural impunity that comes through when we talk about in exalted terms things like encounter killings, which are also in extrajudicial killings, which many of you must be discussing. That is also prohibited if you are a party to the UN CAT. And the CAT committee also plays a very crucial role in terms of investigating cases. So as part of that committee, there is another treaty which has come through, which has India has not ratified, is the OPCAT, which is pursuant to the optional protocol to the CAT. So what happens due to this SPT committee, it's also called the SPT committee, hereby if countries who are specifically who have ratified the SPT, these members of this SPT committee can directly and without any permission, they have the rights to directly go to those prisons, go to those direct sites and investigate what is happening in terms of torture. The idea is not to expose and name and shame the country, but the idea is to prevent any kind of torture that's happening. So the special SPT committee on torture has a very preventive mechanism and a mandate towards them. This torture is something which was not even thought of until the 1970s and the 80s, until and unless the International Court of Justice and the other mechanisms which came through stated that it is a it's a jus cogens norm, the prohibition of torture. There cannot be any exceptions to torture. Mind you, there is exceptions to taking life, but there is no exceptions to torturing someone. So this all those infamous ticking time bomb scenarios, which has been dealt with quite at length by the European Court of Human Rights when you read their judgments. For example, Soring versus UK was one of the very landmark ones. So that's how torture is something which has slowly been prohibited globally, but India has a long way to go. Then we have the Child Rights Committee or the CRC Committee. Just to let you know, the United States of America is not a party to the Child Rights Committee and the Treaty on Convention on Rights of Child. And the only other country to accompany it is Somalia. So that speaks a lot when the US went ahead with their drone programs, and even Barack Obama in his book had justified these drones which have killed children in a massive scale, and there's a lot of bloodshed. So that's the work of the Child Rights Committee, and on the work of drones, they have come up with a lot of jurisprudence, urging states the need for them to ensure that child rights is upheld. And as Professor Atul just mentioned, and I was very curious, that there is a Center for Child Rights in Calcutta as well, not relating to the UN, but an NGO, right? NGO. So that's something which is so significant. That we are in Calcutta and this work might just feed off into the UN mechanisms globally in Geneva. So ICRMW is the next one, which is the least ratified treaty, and unfortunately it has still not come into the picture because this treaty deals with the rights of migrant workers. So there have been only 9 ratifications. It requires 10 state parties to it, which has not happened as of yet. Then we have the CRPD, or the one which deals with disabilities. This is a treaty body which deals with disabled people. Like, for example, there are a lot of jurisprudence which have come through on the rights of disabled people living in armed conflict. What are the special privileges and rights that emanates from the Geneva Conventions for these people. That's the work of the CRPD. And there are a lot of NGOs based in India who had worked towards developing the CRPD for that matter. Then we have the ICTPED, or the Committee on Enforced Disappearances, the one which grew from the whole Argentina situation that I mentioned to you about. And we have the Committee on the Enforced Disappearances as well. So these are the basic 10 core human rights treaty system. There are treaties happening every time, but so far it's been only 10 as of now. So as I mentioned, these treaties, if you ratify them, its obligations are absolute on your countries unless and until you have certain reservations. So many of these treaties, for example, the ICCPR also has an optional protocol on prohibition of death penalty. Unfortunately, since India allows for death penalty according to its laws and even the Supreme Court decisions as well, so India is not a party to the optional protocol to the ICCPR. So what happens is that there's a trend that has shifted that once treaties are being ratified, states have to give up some amount of their sovereignty. And there has to be an oversight mechanism for, as in the words of Concado Trinidad, for jure gentium to be present, or the law of mankind to exist. Right? So that's why there's a threefold obligation which entails for people to undertake, which is to respect, protect, and fulfill once you're part of these treaties. So this is a small highlight of what the treaty bodies entail. So there was specific mandate, each and every treaty body as pursuant to their respective treaties. There's a membership criteria which is present, and there are a total of 172 members considering there are 10 treaty bodies. And they're all international experts in their different domain, or they're mostly lawyers, they're mostly academicians or even practitioners, or even former judges, diplomats who are present there, and they meet in Geneva and they discuss and they deliberate. Now, what do they deliberate about? That's what we'll see in the next slide. So these are the 5 core work of the treaty bodies, starting first with a review of a state party report. So what happens, for example, let's say, take an example of India as a party in the ICCPR, right? So every 4 years, India should be giving one state party report. And along with the state party report, curiously, it also, many stakeholders can also submit specific reports. NGOs, academicians, even students like you. I'll give you one example. When I was at my first workplace at an NGO, I had assisted the RGNUL Human Rights Cell to submit to submit a shadow report on India's non-compliance with the ICCPR in terms of the fact that India for the last 20 years had not submitted a state party report. And that the treaty body had also cited the lawsuit submission as something which was very brave coming from the fact that it is a national law school and it is being submitted. So you see, like your work, if you want it to be out there for the real mechanisms to also take place. I've told Professor Atul also and I'll tell you also that there are always calls for different reviews or different submissions from different experts from these treaty bodies, which you can always submit. There's a specific pattern which you'll find out on the OSCHR website. You have to follow this pattern and you can make your voices heard. So although India has not ratified any of the optional protocols, but if you are a party to the certain optional protocols of 8 treaty bodies, it also allows those members of the treaty bodies to take in individual complaints. So now what are individual complaints? So for example, if someone in this country has his or her has had his or her rights violated or some family members forcibly disappeared, and even the Supreme Court, the highest court of the land, has also just thrown the case away, and there has been no remedy. If that specific citizen's country, like for example, if India were to be a party to the ICCPR's optional protocol, then that specific person could have also filed an individual complaint against India before the treaty body, for example, the ICCPR. So in that light, recently, in terms of climate change litigation that have come through, it works as a quasi court So there were Torres Strait Islanders who were displaced from Papua New Guinea, from Kiribati, Fiji, who had filed a case stating that Australia had violated their rights and did not acknowledge climate change induced refugees. And whereas the UN Human Rights Committee had given a decision that they should, and there was a lot of wonderful jurisprudence on that. Similar was the case of cases involving Malta and Italy, when it spoke about the extraterritorial reach of the CCPR primarily, and it was during the heights of the whole refugee crisis which had happened in the Mediterranean during the heights of the Syrian civil war, when people were fleeing and going. And there's also a very great movie on Yusra Mardini. It is on Netflix as well. I think it's called Swim for Survival or something. But again, that will showcase the plight of these people that had gone. Then interstate complaints. So just like at the ICJ, where one state complains against the other or deals with them, some of these treaty bodies also permits one state to make a complaint against another state. It did not really work out. Only 4 or 5 years back, when the third committee had its first ever interstate complaint case during the heights of this whole diplomatic tiff between Qatar, Saudi Arabia, and UAE. So that was the first time that the interstate complaints mechanism was used by two states, and it has not been used after that. And fourthly, and very importantly, during your moods you must have quoted a lot of general comments and all those things that come through. So what are these? So basically, different treaty bodies interpret a specific provision of that particular treaty, and then they come up with an interpretive guidance on what that provision can entail. So, for example, the general comment 12 on self-determination long back had spoken about self-determination as an erga omnes principle. And that has also been taken, and that has also fed into the workings and the jurisprudence of the International Court of Justice as well. Similar, it has been with the right to life general comment and right to peaceful assembly, which is general comment 37. So these are specific provisions under the ICCPR, which the UN Human Rights Committee has interpreted and come up. Similarly, for example, the CEDAW committee or CAT committee has done so for their specific treaties. And finally, it actively works towards prevent human rights violations. As I mentioned, the subcommittee on prevention of torture directly visits sites where torture is being committed. The CERD has a very interesting early warning mechanism system. It's a very technical system which I'll not go into right now, but just wanted to highlight. So having stated the important works of the treaty-based human rights mechanism, we move on to charter-based mechanisms and we move towards the work of special procedures. And as you can see, can anyone recognize and tell me who are these four members? Any one of you know who are these people? I guess not, but I'll tell you what. So as you can see, so far we have had only 4 UN special rapporteurs. They're called UN special rapporteurs or as part of the special procedures. Recently, Ashwini KP became the first ever Indian woman and the first ever Dalit woman to be appointed only in December, I think in October 2022, the special rapporteur on racism. And her work has primarily highlighted the whole caste-based racism. She is a Dalit person, and something which India often ignores and prohibits in its international engagement to recognize caste as a form of racism, as a form of discrimination internationally. Second, beside him on the right on top, you see Mr. Balakrishnan Rajagopal. He is currently the UN's mandate holder, the special rapporteur on housing. Right below him, you see Mr. Anand Grover, who was the first UN special rapporteur on right to health, which is not evolved right now. He was a special rapporteur almost 20 years back. And on the left, as you can see, the spectacular person, it's Mr. Milun Kothari. He was also a special rapporteur on right to housing, and now he's a member of the Commissions of Inquiry on Israel and Palestine issues, which I'll touch upon later. So as you can see, the special procedures are basically individuals who are tasked with either a thematic situation, like a housing, or a country situation, There's a special rapporteur on Belarus, there's a special rapporteur on Iran, and all the specifics. So what do? They have a wide-ranging task. Amongst them, with the growth of technology, you will see, I've mentioned the name of Alice Edwards. She's the first ever UN Special Rapporteur on Torture. If you just go on LinkedIn or Twitter, you'll see her engaging with direct advocacy online. Whereby even students like you all, if you want to submit something and reach out, these people and their teams are always open. So there is a direct engagement with people and there's advocacy at large which goes through each and every day. So if there are instances, they send appeals, letters to the state. So what you might now question as to what is the purpose of all of it? They're just doing it, they're raising voices. But international law works through argumentative practice also. And this is something which Professor Monica Hakimi had written, this whole idea of argumentative practice. And that's how international law of modern days and times have grown. Where through naming and shaming, by showcasing some light on a particular issue, international law concerns are taken into account. And there have been studies where it has been proven that it has really worked. Then they also develop a lot of standards. For example, as I mentioned, Istanbul Principles was developed by the UN Special Rapporteur on Torture, how to investigate torture. Similarly, the Mendes Principles were developed by UN Special Rapporteur on Torture, Mr. Mendes. And then there is also the Bangalore Principles, which was developed by the UNODC, but it was also supported by the mandate holder on independence of judges, UN Special Rapporteur. So there's a lot of development of different international standards which come through. So international law should always go one step ahead, and these are the people who take that flag forward. So you have read about Lex Lata and Lex Ferranda. Right? Lex Lata is the law as it is, and what law should be is the Lex Ferranda. So these people are the beacon of hope for the Lex Ferranda to come into the picture, which might not exist right now, but might come through in the future. So that's the work of the UN Special Rapporteur. Now we go to the Universal Periodic Review. I mean, this is like the crown jewel of the UN human rights mechanism. And this is very famous quote by Voltaire, who was supposedly atheist. He said, if God did not exist, we would have to invent it. So just the same way, if UPR would not have existed, people inevitably, international community would have invented it, and now finally they have come through. So what happens with the Universal Periodic Review? So right now, India, for example, had its fourth review of its state of human rights that had undertaken only last year in the month of October. It was Indian delegation was led by Attorney General Tushar Mehta, and there's obviously a lot of criticisms in terms of India's state party report and everything. But in a nutshell, what happens? The process begins in a cyclical manner, as you can see. A state which is under review, for example, India, submits a state party review on a lot of those treaties that they're party to, and additionally towards any kind of human rights concerns that they address. So technically, states really showcase their best side. They'll never show as to what they're failing. So once they submit those reports, the UCR committee then also calls for stakeholder submissions from different NGOs, from different civil society activists, from different UN bodies, from academicians, from students for that matter. So for example, if there's a UPR of, let's say, Australia happening, and some of you guys are really interested in the rights of migrants and refugees, that is a problem in Australia and they are discriminated, you can submit a report as well, and you get acknowledged in the final outcomes on those reports. It's something which is not really known for students in India, but I've seen abroad how students actively participate and promote international and push their states to uphold the human rights standards. So what happens when these reports are collected? These parties, the state party, the stakeholders, all gather in Geneva, mostly, many of the times. And in Geneva, there's a discussion that happens. And after the discussion, many states allege the other member states tell that, okay, India did not do this, India did not do that. Whereas the Indian representatives, usually, they try to defend themselves. And finally, as an outcome of this whole process, there are recommendations which are provided by the UPR committee for the states to accept. And 4 years later, again, it is seen if these recommendations have been worked on. So this is the primary function of the UPR mechanism, which ensures that states are always in the limelight and brought to the limelight with the work of the UPR mechanisms so that the violations is not let go scot-free. So there is this whole pre-review and post-review process that happens so that it ensures that this whole process is not just left in limbo or in the air. So before the process that starts in Geneva, there is the whole mechanism that comes into the picture. And after those recommendations have been given, if a state is implementing or not, that also happens. And just to give a personal anecdote of mine, when I was in 2018, for the first time, the National Human Rights Commission of India had submitted its midterm report on the UPR towards India, which was coming up in 2022. It had never happened before. I was very lucky that I could train the National Human Rights Commission members on the UPR process, which is such a disappointment that a National Human Rights Commission does not really know how a UPR works and why it never had participated. So it's always a push and pull that happens with state entities when you want to work with them. But this is in nutshell the UPR mechanisms. And now finally, penultimately in terms of the mechanisms part, I know I have given a lot of information out there, but simply the commissions of inquiry are just mandated to inquire, find facts, and apply the law and to see if there is a violation that has happened or not. For example, we saw the whole uprising in Iran, a women-led uprising in Iran. These three members have been selected as the commissions of inquiry on Iran. And the one in the center is the Bangladeshi civil society activist herself. So now we have seen previously it was purely a fact finding, but now there is an accountability turn. Globally, in every aspect in this soft law measures, there is always an accountability turn that has happened, whereby they do not just find facts, but they also apply the law to see if there is a violation or not that has happened. For example, in Syria, in Libya, in Myanmar, in terms of Rohingya, these commissions of inquiry came forward as with their ground reports by applying the law and to showcase as to how violations have happened. Now, finally, before we move on to the part as to what India has done so far, questions might arise that with all these mechanisms, is there a conflict? Is there a duplication? Is there a fight between them? We see, like in Indian bureaucracy for that matter, we see that, okay, this wing of the government is fighting, there's a turf battle or not. Well, it's mostly collaboration that has happened rather than competition. Because every mechanism is separated in its own unique way, as well as there is an overlap and there is also shaking of hands between different mechanisms as well. Now, what has it led to? For example, the works of various commissions of inquiry has led to transitional justice happening in failed states or so-called failed states. For example, post Yugoslavia, the commissions of inquiry had helped ensure the right to know the truth and all these mechanisms of transitional justice come through. Then, for example, before the International Court of Justice, you must have seen a few years back when the Gambia brought the case against Myanmar under the Genocide Convention. A lot of the evidences that Gambia presented, and he was the foreign minister of Gambia, Bar Dembadok, they depended and focused on the works of various special rapporteurs on Myanmar, the works of commissions of inquiry on Myanmar to showcase that the Rohingyas were being persecuted and the standards for genocide was happening. So they help in the services of other international mechanisms. And finally, two more things, they help in advocacy campaigns, Amnesty International, Human Rights Watch. I've been told that you will go to International Justice Mission and all those civil society, they are very actively involved with the UN mechanisms. So even if you intern with them, or even if you write to a UN special rapporteur yourself, if you want to develop more interest in international, they're very willing to take in interns, they're willing to take in professionals or research scholars. Like when I work with the UN special rapporteur on freedom of religion and belief, Mr. Ahmed Sharif, Professor Ahmed Sharif, I was right out of my LLM and I got a fellowship which was sponsored by his institution, and that gave me a lot of insider perspective of the work that undergoes. So you see, this is a whole roundabout mechanism where you yourselves can be part of, and you can also help finding the development of various areas of international law that has come through. For For example, the Commission of Inquiry on South Sudan had showcased how starvation is not just an international armed conflict issue, but also a non-international armed conflict. For example, UN Special Rapporteur on Extrajudicial Killings, former UN Special Rapporteur Agnes Callamard, who is now the current chairperson of Amnesty International, had showcased us the problems with drone warfare and the problems with the whole Khashoggi incident which had happened in Saudi Arabia. So there is a real-time, real action stuff that you'll be part of, and you'll not just be relegated towards the classrooms. So now finally, after having perused through the mechanisms, we'll just wrap up steadily by just throwing some light on where India must go forward still. So India has been appointed as member of the UN Human Rights Council, elected rather, for 6 times. This is the 6th time they are serving it. The current term ends in 2024. It's always a 2-year term, and it begins. So how will you elect it, basically? So you have to give some kind of pledges. You voluntarily pledge, okay, we'll do this, we'll do that. Yes, you might say that is diplomatic speak for real politics, but that is what the reality is up to. So India states will do this. So India had submitted 28 voluntary pledges, including the most important one on ratifying UN CAT, which India is yet to. Although it signed it in 1997, there has been a lot of campaigns, and yet it has not. So now, in terms of compliance with special procedures or the special rapporteurs, as you can see, we have complied with 10 requests, and the most important one was back in 2010 or 11, if I'm not mistaken, when Christoph Hanks, the special rapporteur on extrajudicial killings, had visited India and especially inquired onto the issues in Northeast when there was extrajudicial killings that had undertaken in Manipur for that matter, which ultimately led to a case before the Indian Supreme Court. Then the UN Special Rapporteur, a few of them, and even the Office of the High Commissioner had also intervened before the Supreme Court when the whole CAA, NRC cases were being heard as well. And yet there's a lot to be done because there are 21 requests pending which has not yet been accepted by India. Because there is always a fear that external influence will take away India's sovereignty, considering our past history with colonization. So as you can see, that India has complied mostly with the CRC and CRPD committees, but the much more action-oriented treaty bodies, CCPR, the ICCPR, for 20 years, India has not submitted a state report. The CERD, India always has a problem, like I mentioned, in terms of caste-based discrimination. And even the Child Rights Committee. So there's a lot to be done. And as future lawyers and future human rights lawyer, I hope that you can be part of these mechanisms and showcase that you can be a UN human rights expert. Because after all, at the end of the day, there is this very famous term that Professor Nigel Rodley, the former UN Special Rapporteur on Torture, had mentioned that sunshine can only happen when light is thrown upon these abuses, and that's when states will come forward and comply with it. And ultimately, in my experiences so far, having worked with an NGO, having worked with even special rapporteur, with states, and now finally as part of an international organization, focusing on my mandate is to work on Human Rights Council itself. It showcases that human rights and development is not a triumphant truth, but these are all thousand humble stories which you can also understand and feel, and that's the fountain of knowledge that you can also gather. Thank you very much for your patience, and I look forward to any questions, clarifications, whatever you want to have. I'm happy to answer them. Or criticisms as well, please.
Hi, good evening. So I have two questions.
Your name.
I'm Arya, I'm a third year. So my first question is related to the regional court systems present across various continents, specifically Europe and both the Americas, the ECHR and the Inter-American Court for Human Rights. But there is a clear absence of a regional charter and a regional court in Asia. And from what I've read, most of the reasons are that Asia is a very diverse continent with respect to different paths. You have the entire Middle East, which follows a different law in itself and have a lot of laws related to Sharia law specifically. Then you have India and the whole subcontinent here, which has different regions. Then you have Japan, the Philippines, the Vietnam, and it brings a lot of diversity, because of which it is difficult to establish a human rights charter for the continent and the whole. But is there a way that you can overcome this and actually establish one? Because if you see that the ECHR and the Inter-American Human Rights Courts have brought up a lot of cases which have helped a lot in the human rights jurisprudence there and the developments there, which is clearly lacking in the Asian continent. So how can we deal with that?
Right, that's a very pragmatic question, and that's something which I used to think about, that I'll write my thesis on, as to how Asia can also have its Asian Code of Human Rights. And just letting you know, the Arab Code of Human Rights is also there, just by the way, much like the African Code, as you mentioned, rightly mentioned, the European Code, which is like the crowning glory of regional human rights mechanisms. And as he rightly pointed out, there is always a problem of cultural diversity, which brings through. As you must have heard a few years back, our honorable Home Minister had mentioned that we'll follow the Indian way of human rights. We don't want to be imposed. So this is a common narrative which comes through, because one has to understand, look at the larger context, that Asia has suffered from colonialism quite a lot. And there is always a fear that the standards of human rights imposed upon them will take away their own rights. But having said that, now there is a different changing stance that is happening. So these are all incremental steps. It is not just one big action that can come through. Unfortunately, the SARC could have been a great maneuvering space for South Asian countries, but due to the whole conflict between India and Pakistan, SARC almost does not, function at all anymore. So what we have is in the ASEAN, the Southeast Asian nations, the Association for Southeast Asian Nations, are promulgating a human rights code, for which a lot of these Southeast Asian countries are also ratifying their own statute for that matter. In the aftermath of the whole Duterte situation in the Philippines, even Malaysia ratified. There's a push for that's happening. But at the sake of probably promoting the organization that I work with, which is the Commonwealth Secretariat, what happens is that now that I'm seeing is the Commonwealth Secretariat, which is a secretariat, an international organization of 54 member nations, and many of them based in Asia, we try to bring a unifying voice with the help of our good officers of the Secretary General, whereby an Indian delegate and a Pakistani delegate and a Bangladeshi delegate can come together and present its problems. And has it been a success? A small glimpse of it. For example, the loss and damage fund, which was being negotiated at the last COP in Sharm el-Sheikh in Egypt, the whole idea of loss and damage emanated from the Pakistani floods that had devastated that country. And there were questions that why is countries in global south, or countries like Pakistan, India, we have the Sundarbans nearby, which can be a problem. We have Bangladesh, which is an LDC country, who suffer from the devastating effects of climate change when the full problems are being perpetrated elsewhere. That's when the negotiation of loss and damage came through. And people who are experts primarily in environment can also state this whole idea of common but differentiated responsibility regime that comes from there. This whole loss and damage fund, it was the work of the Commonwealth which had come through, and finally it was enshrined at the COP27 in Sharm el-Sheikh, and it was led by Pakistan themselves, and India was a very active contributor. So herein we can see that in these specific issue by issue, which really concerns the entirety of the regions, states do tend to come under one umbrella. And so far, unfortunately for South Asia, it could have been the SARC, but right now the Commonwealth or even the ASEAN is assisting for common voices to come through, because that brings a lot of strength before these big bodies at the UN or like the General Assembly or the COP, for voices to be heard and concerns to be raised. So I think it's a process going forward, and I'm optimistic about things changing, especially with ASEAN coming up with its human rights code. Yes.
I'm Rudra, right? And I'm a third year student. My question is primarily relating to the implementation of the UN ideals. So a problem that we generally see when it comes to Middle Eastern countries such as Palestine as well as Israel is that while the UN is more than willing to help, more often than not, these communities, they're not ready to allow the UN to help them out. So do you think there is a dissonance when it comes to the approach to human rights, where we see a lot of countries on a domestic level follow a bottom-up approach, where the real strive for help come from down below, and you have the Supreme Courts and the legislature then listening to them and bring about the change, while the UN itself goes for a more top-down approach, telling the countries to do this from the top? Or do you think it is the conditions and the pervading circumstances of strife, dispute, and war that make these countries really hold their cards closer to their chest and not allow external influence of any kind?
Right. Very interesting question, a timeless question rather, that has always been raised about the regime of international human rights law, international criminal law, international humanitarian laws, all overlapping as to is the UN really working. But here it brings me to light, a paragraph from the Nicaragua US case. I'm forgetting the paragraph number, but it said that violations of law does not mean the law does not exist at all. It exists, rather it reinforces the need for those laws and standards to be met. That's the idea that they put forth. Now, after that, what has it worked out so far? In the Israel-Palestine conflict, for that matter, in UN has been a direct party in negotiations always. Even during the whole Abraham Accords that President Trump had led through, the UN Secretary General was very much party to it. And before that, Kofi Annan's lasting legacy was being party to the negotiations. Now, if these negotiations fail or not, that's the political question that comes through. But will UN stop at not being party to it? Yes, it has stopped. It was a big failure in Rwanda. It was a failure in Yugoslavia, which the United Nations themselves acknowledged. However, having said that, there are some limitations within which the regime of the United Nations has to work through. For example, during the earthquake that happened in Turkey and northwestern Syria, due to the fact that there's so many embargoes, there's so many sanctions placed on them. There's only a single humanitarian corridor that was being allowed by the Assad regime, which was also wrecked due to the earthquake. And UN was powerless. And there are a lot of voices coming through. You are helping Turkey rebuild itself, whereas people over there in Syria were bombed just 20 minutes after the earthquake had happened from the Assad regime. What are they going to do? What will how will they respond? So you have to understand here the various mechanisms of the UN. That's why the Human Rights Council is being there. Beyond the larger structural mechanism, the individuals are there. Like the special rapporteurs on Israel-Palestine is there. The Commission of Inquiry is coming up with reports which has shed light onto the fact as to how Israel is committing apartheid. There's an apartheid regime being placed. How did these terms and acknowledgements come through? Like I said, it is an argumentative practice through which success is being attained steadily, but slowly. But then there have been successes. For example, in post-conflict situations in Yugoslavia, the commissions of inquiry, the Basauni Commission, had come up with so many innovative ideas of bringing people together and reconciling. Even in the case of Rwanda, for that matter, yes, UN could not prevent it, but after that, is there inflaming happening? Not so much, because the UN played a direct active role. But here, UN also has to be careful in not being too interventionist in its policies, because then states will also tend to withdraw itself away from the United Nations. That's why you see in the case of India, whenever, for example, Mr. Khurram Parvez, who was a Kashmiri human rights activist, who has been held incommunicado for more than 1.5 years, he recently got the Martin Ennals Award. It's the highest human rights award in Geneva. He was not allowed to go, obviously, he was in jail. And the UN Special Rapporteur on Human Rights Defenders said that I'll follow his trial closely, which happened on Saturday itself. And the Indian diplomatic service immediately came back with a defensive response. So that's what you have to find the spaces of collaboration and steadily try to bring success. It cannot be, as you mentioned, it cannot be top down always. It cannot be that I tell you, you do this. It should be let's hold hands together and go forward. And it is a work in progress, just like a mechanism in India to prevent murders happening or rapes happening or crimes against women and children happening. So I think this is the process so far. But I'm just hopeful that it will happen.
So my question is mostly regarding to how the first and third world countries have approached human rights. For example, most of these treaty bodies and how most of the human rights ideas have come into place, they come in from a position where these first world nations have propagated their own morality or philosophy of how human rights should look like. Right? In such a circumstance, where do you see the third world countries and how their culturally different realism towards these human rights approach will play a part?
Right, thank you very much. If not for this lecture, I would have actually suggested, Atul, let me speak about India's contribution to the UDHR. So there is a lot of literature that is now finally coming through to showcase, to bust the common myth that countries like India and other developing countries or newly decolonized countries never participated. India did participate at larger UDHR, led by the delegation of Vijayalakshmi Pandit, Hansa Mehta, and even Mahatma Gandhi's support himself was there directly. To give a small anecdote, when the whole issue of self-determination was being discussed under the mandate of the UDHR, there's a lot of pushbacks from the South African delegation because of its racist policies in southern Rhodesia, even in the Southwest Africa situations. India was the one who had gone through without accusing South Africa, but rather bringing them on board in order to understand and shed light as to why the need for this provision in the future would be required. And because of Vijayalakshmi Pandit's excellent oration and negotiations and diplomacy, even the South African government personally had sent a note to Jawaharlal Nehru and Mahatma Gandhi stating that we have sent like the next hope for human rights from the South Asian context. So having said that, yes, it's a common understanding that human rights issues pertaining to LGBT Q plus people, human rights issues pertaining to environment is really being generated from the West and it is somehow being imposed onto the third world countries. But having said that, we have to understand that the basic text of human rights, which emanated from the UDHR, also had a lot of India's contributions. For example, if the word every human being was implemented by India, previously it was every man that was being removed. For example, the ideas of color, the ideas of race, and all this, so many aspects. There's a huge documentation as to how India contributed in terms of the text that really happened. But over the years, yes, many of these third world countries themselves, even after being decolonized, even after being freely independent, have really pulled themselves back away from multilateral institutions. And they have really engaged only in bilateral mechanisms. But the future of humanity lies with multilateral institutions. States have to engage at this institutions, like the WTO, to get some concessions on your tariffs or something like that. We saw that happen during the COVID matter when the WHO really pushed it forward. So what I feel is that these third world states and developing states, these developing countries should give up the idea of being victimized and rather start leading the process. And that I can give an example of Fiji for that. When I was in the Human Rights Council for the first time, the president of the Human Rights Council became a representative from a small island state, the Fijian ambassador to UN Geneva, Ms. Nazar Chamin Khan. So Fiji had done a lot of remarkable work in terms of promoting the rights of small islands. So much so, now thanks to Vanuatu, which is another neighboring country of South Asian Pacific country, a case of advisory opinion on climate change and the impacts of climate change has been submitted for the UN General Assembly, and which in all probability will be going to the ICJ for its advisory opinion. For example, in another instance, the Chagos Island advisory opinion, very famous Chagos Islands, where the US had maintained a base of that island of Chagos in Mauritius. It was the success of third world nations. It was success of the for people who wanted things to be decolonized. Colonization should not exist anymore. So I think sometimes in our newspapers, in our daily discussions, we seem to miss out on the steps that are the success that has also been attained, which is not perfect, but something which can be worked upon. Because even in the recent past, we see that these successes have been attained. Is there any other questions?
one more question I had was with respect to the role of corporations in human rights matters. So you referred to the Ruggie principles and the UN guiding principles for businesses, but most of it is soft law, and these are guidelines that corporations are expected to follow. But so my idea and understanding comes from major sporting events held in different countries, and so I am talking about the FIFA World Cup in Qatar and the Winter Olympics in China, and how the sponsors as well as the state in itself were responsible for conducting human rights violations, and how there was a lot of backlash. But in the end, because most of this law is soft law and nothing would be implemented, these events were organized successfully, and now even the World Cup, which faced so much backlash, has been conducted, and we can refer to the Commonwealth Games that was conducted in India in 2010 as well. How a lot of a big population of poor people in Delhi was forced to move out of that particular place, and yet in the end, no decision is taken upon them and can be taken upon them, because a lot of it is the responsibility of the corporations that were taking part in that particular project. So how do you deal with that, especially in reference to soft law?
I very rightly pointed it out. I'll state it in three parts. First, it's not just recently. For example, when I showcase the example of Argentina in 1986, I think Argentina hosted the World Cup, also football World Cup, and it was under a military rule that time. And there's also, I think, this Netflix series called The Dictators or something like that, which will showcase that instance as well. So it has been a historical trend for militant rulers or right-wing fascist rulers to almost do sports washing or green washing or human rights washing by hosting such events, which has been a common claim. Now, what has happened with the UN guiding principles, which is yet to really evolve in the South Asian context, but within Europe, within specific countries in Europe, and even at the EU level, there have been binding guidelines that have come through, which companies are forced to work with. So, for example, when I was part of this multinational enterprise, which was dealing in luxury, and we were working with a lot of mines and a lot of recruitment of mining workers in Myanmar, in Afghanistan, to get those diamonds for that matter. So we had to follow those guidelines in terms of the sanctions that came in post-Russian invasion, because Russia provides the 90% of the mines that comes through, and it comes to India in Surat, and it gets polished and then sent all over the world. You see all those Cartier jewelry and all those beautiful neck pieces that come. So you're very much mandated towards following this sanctions regime. Otherwise, the local Swiss government, which has its domestic business and human rights laws, would have then prosecuted our chief executive officer and all this person. So I could see literally fear in the minds of these people because they did not know about sanctions regime and how did it work. Now, having said that, have there been instances indeed? Lafarge Cement and its CEOs are being prosecuted in French courts for accusations of supporting crimes against humanity in Syria, because they were conducting business operations still there, which were ensuring that the blood money is being sent through. Then there have been Swedish corporations that have been prosecuted. CEOs have been jailed for that matter, for human rights violations as part of their company's architecture. But why now? Let's talk about a few years back what Bhopal gas tragedy itself. That is a sample of human rights mechanisms, although not in the official terms right now. That did happen. I mean, there was a diplomatic fallout, and the person responsible was not jailed and had escaped. That's a different thing. But courts did take cognizance, and there was a decision given. Right now, what is happening at the UN is that a binding treaty on business and human rights is being negotiated, following from the UN guiding principles itself. A treaty much like the ones that you saw. Maybe it will be the 11th treaty, and states hopefully will be a party to it, because corporations have for long really evaded this the whole shadow of human rights mechanisms. But I can tell you from experience, primarily in the European context, unfortunately only right now in the European context, that corporations are having to take active steps. And right now, even in India for that matter, if someone works with as a consultant with Deloitte, I've seen people are having to work with ESGs. And what is happening? These companies might be, I'm not talking about Deloitte, maybe an agriculture firm or a big mining company might be headquartered in UK or Switzerland or Germany, but then their subsidiary work is also happening in India. So these companies in India are also, their subsidiary organs are also having to follow those laws. So as you can see, there is a percolation of this laws that is coming through, which slowly states in this in the South Asian context are also are forced to deal with. Myanmar produces a lot of rubies and a lot of jewels for that matter. But now even companies over there are either being told to stop operations or being told to really comply with the laws in place and not really feed onto that whole blood money mechanisms that is being run by the generals after the coup that is happening. So you see, it's a complex picture where everyone's fighting for its place, and that's why I always reiterate that human beings, normal human beings, corporations are all subjects of international law and not just states. So it has moved beyond the idea that states are the only regulators and the subjects of international. But each and every individual sitting right here, and even the places that you work with, are subjects of international. So I think on that note, I would like to state that there is hope. It's happening. It's not as if it's being ignored, especially in the Russia-Ukraine context. I've seen COVID context. It has happened. So hopefully, this will be happening.
Any further questions?
Thank you very much. It was lovely.
Respected Mr. Sarthak Roy, our faculty advisor, respected Dr. Atul Alexander, and dear participants. It is my privilege to offer vote of thanks on this occasion. I am Mansi Lodha of ILSA NUJS Chapter 22-23. Take this opportunity on behalf of the entire society to express our gratitude for the informative and the thought-provoking lecture. It was truly enlightening session on the very burning issue of demystifying UN human rights system, witnessing accountability in action. It was truly a pleasure listening to you, sir. We assure you the valuable assessment of human rights that you have raised will help the participants in days to come. Secondly, we would like to thank Dr. Atul Alexander for his constant support in organizing this lecture. Finally, we would like to thank all the participants for actively participating and asking such astute questions, which made this session successful. Thank you everyone for joining the lecture. We at NUJS-ILSA promise to host more enlightening lectures in days to come. It was truly a privilege to interact with you, sir. Thank you so much. Yes, now I request Atul sir to facilitate Mr. Rao. Thank you.
We'll take a group photo with
Everyone please join.